All rise. The First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have 3 cases on the docket today. We will take them in the order that they appear. We will take a break after the second case and invite counsel and any parties to join us in the rotunda for a short coffee break. We'll then reconvene for the third case. The first case on our docket today is Cynthia Williams versus Public Supermarkets Incorporated. Counsel, if you're ready, you may proceed.
To reserve 5 minutes for rebuttal.
Okay, so noted.
Reversal is the right result in this case for 2 independent reasons. The first one is that the trial court denied Ms. Williams the right to due process when it conducted the summary judgment hearing while she was without counsel, despite the fact that her former attorney had secured 30 days for her to find a new attorney when he withdrew, and the trial court granted that request before dismissing the attorney from the proceeding and then turning to the substantive hearing. The second reason is that the trial court erred on the merits in granting Publix's motion for summary judgment because Publix did not carry its burden as the moving party. Now, on the first issue, what happened here was a breakdown in the way the judicial system is supposed to run. The Myers case cited in the initial brief from the 5th DCA talks about how important it is to allow even civil litigants the right to an attorney to represent them. It's important to have an attorney to navigate the adversary system. It's important to ensure accurate results. And it's important for public confidence in the court system. Now, I think just stating the facts of what happened shows the problem here. As I mentioned, Ms. Williams' attorney moved to withdraw, came to court for a hearing on that motion. The court granted the motion to withdraw and granted the request for Ms. Williams to have 30 days to find a new lawyer, turned to Ms. Williams and explained to her the importance of having a lawyer and told her that she has the opportunity to find one, to go out and interview lawyers to find out who she should get. And then as soon as that discussion was over, said the next thing on the docket is a motion for summary judgment. Publix counsel stood up and made the substantive argument on summary judgment. The trial court turned to Ms. Williams and said, basically, I don't really expect you to have an argument, but what do you have to say? And she says, I'm not a lawyer. What is he talking about in reference to summary judgment?
Sure. And so could you walk us through a little bit more of the procedure leading up to the hearing? So how long had the case been pending at the time that the case management conference was set in January of 2022?
I believe, as the Publix mentioned in the answer brief, they had been pending at that point for 18 months. At least it was 20 months by the time the case came to the hearing.
And Ms. Williams was represented all the way up to the point of the hearing when the motion to withdraw was granted, correct?
Well, technically, she had an attorney of record up until the time the motion was granted, but practically speaking, she did not have an attorney representing her from the time her attorney filed the motion to withdraw.
So it was about a month and a half
Yes.
at that point. So let's say, at worst, about a month and a half without counsel. And did Ms. Williams or her attorney seek a continuance once the motion, as the motion to withdraw was being considered or after it was granted?
No one uttered the magic words, "Can we please have a continuance?" But the trial attorney did ask for her to have 30 days to find a new lawyer. And for all intents and purposes, that is requesting a continuance because the trial court should have understood that nothing substantive could happen while Ms. Williams was without counsel unless it made some finding that she did something wrong to cause herself to be without counsel or that she had abused the process.
Okay, and let's also talk about the notice of this hearing. Was this noticed as a hearing on the motion for summary judgment?
Yes.
Okay, where in the record can you point me to that?
The notice, I'm pretty sure that the notice that this was a hearing for summary judgment is not in the record.
Okay, so it's not in the record.
Correct.
All right, so how are we to know that Ms. Williams had proper notice that the summary judgment motion would be heard on that January 4th case management conference?
Well, this appellate court doesn't, I suppose, know that, because I'm pretty sure, and I'm sure that Public Access Counsel will correct me if I'm wrong, but I'm pretty sure that the only notice in the record was that I'm not sure if the notice for the summary judgment hearing was in the record, but I would say that Ms. Williams, as a pro se person who, it is clear from the hearing transcript, had no idea how to conduct herself in court, would have no reason to know that there was a summary judgment hearing coming up, because she was counting on her attorney to usher her through the proceedings.
Well, in terms of your due process argument here and right to counsel, isn't that a pretty important fact about whether this was properly noticed and whether, rather than simply looking at the motion to withdraw, that was Ms. Williams on notice that she was to present argument in opposition to the motion for summary judgment?
I don't think that is important, Your Honor, to my due process argument, simply because the due process problem was that she was left without counsel, even though he secured the right for her to get a new lawyer. And the reason I'm not sure if the summary judgment, the notice for hearing is in the record, is I know that Public said that in the answer brief, and I did not contest that because I know it to be true based on the trial court record. And Publix could have supplemented the record with that. So to me, I didn't see that as an important question, simply because the real issue was that she was denied the right to counsel.
Okay, thank you.
So, again, the fact that the case was noticed for summary judgment hearing is something that Ms. Williams' attorney would have known, but he moved to withdraw 2 weeks after Publix filed its motion for summary judgment. Up until that time, he had no reason to file any evidence in the record. He still would have had time remaining to file a response to Publix's motion for summary judgment. But he moved to withdraw because he was discharged. Therefore, if he had continued to represent Ms. Williams, he would have been in violation of the rules of professional conduct. And that's Rule 4-1.16, I think it's E3, cited in the briefs. And so he couldn't file anything on her behalf, but at the same time, he was the counsel of record, so Mrs. Williams couldn't have come in and filed anything on her own behalf. And so that is the due process problem.
Do you see the right to counsel and the due process right as one and the same, the nature of the right that you're seeking to vindicate here?
Yes, Your Honor, and that is supported by the Scheinheit case from the 3rd District, which is about as on point as a case can get, where essentially the same thing happened. In both Scheinheit and this case, the trial court granted a motion to withdraw, gave the litigant time to find a new lawyer, but then held an important substantive hearing while that litigant did not have a lawyer. And the 3rd District held that was a violation of the right to due process.
So thinking conceptually of this right, we generally think about procedural due process rights as fair notice and a meaningful hearing. So can you articulate for us how we should be thinking about the right to counsel and the way it fits into that notice and hearing that you're entitled to for the purposes of due process?
Yes. Ms. Williams did not have fair notice of either the summary judgment hearing or the fact that she would be required to argue it without an attorney, because she had every right to expect that her attorney was taking care of things, and her attorney did try to do that by asking for the 30 days and even got that result from the trial court. And so when the court turned around and held a substantive hearing, that blindsided Ms. Williams and the trial court conducted a hearing without fair notice to Ms. Williams because she had no reason to believe that the trial court would hold a hearing where she had to represent herself when she had a lawyer and he tried to secure the right for her to continue. I imagine if the trial court had denied the motion to withdraw or denied the right to obtain counsel for 30 days, surely the attorney for Ms. Williams would have asked for a continuance at that point. And instead, the trial court granted the 30 days. And so when the trial court turned around and went back on that, that was a surprise. That was not fair notice. Ms. Williams had no opportunity to prepare. And again, I would point you to the Scheinheit case, and which is essentially the same facts. And the third district said, this is a violation of due process. This is a breakdown of the system. And I would point you to the Myers case that says denying a civil litigant the right to counsel undermines public confidence in the court system. The court system.
Okay. Go ahead. Complete your thought and I'll ask your question.
The court system has a preference for deciding issues on the merits. And this was a case where there was no fair opportunity to have this case decided on the merits because, as Ms. Williams said, she didn't even know what summary judgment meant.
So I guess my question is, when a trial court receives a motion to withdraw asking for, X number of days for the client to obtain new counsel, is there always an implicit motion to continue everything in the case? Does the case essentially stop moving at the point that that motion to withdraw is filed, and what principle of law supports your argument?
I would say yes, Your Honor. And the principle of law is the rule of professional conduct that I mentioned earlier that says you can't, once you're discharged as a lawyer, you can't continue representing someone. Mm-hmm. And yet we know that for whatever reason, the court system is set up to require the court to allow a withdrawal. The attorney cannot unilaterally withdraw. They had to get a ruling from the court.
And in fact, the rule says that the representation is not terminated until there's a written order from the court, right?
I believe that's right, Your Honor.
So at the time of the hearing where she's purportedly representing herself and acting pro se, there isn't a written order. So could we conclude that she's actually represented at the time of the hearing still?
Oh, that is an interesting question. And, I'm not sure. I would say that if she was still represented, then there was still a due process problem because the court excused her counsel. He doesn't say anything else for the rest of the hearing. Everyone at that hearing assumes that she no longer has a lawyer, including herself and the judge and Publix. And I would argue that if Publix wanted to move things along faster, it could have perhaps, agreed to an agreed order on a motion to withdraw. I'm not aware of any rule that requires the parties to come to court, but for whatever reason, this was something that didn't happen until there was a hearing. It may be that is the local policy, the way it goes. But, Publix didn't do anything to move this case along faster either and was well aware that there was a motion to withdraw pending.
How many days after the motion for summary judgment was filed was the motion to withdraw filed?
That was about 2 weeks. I've got the dates here. Let's see. October 27th was when the motion for summary judgment was filed, and November 10th was when the motion to withdraw was filed. The motion to withdraw was later amended because trial attorney had not obtained Ms. Williams' signature. But all along, Publix knew that this was pending.
Is there a time limit for filing a response to a properly supported motion for summary judgment?
There is, Your Honor. And I do not know the exact time right as I'm standing here, and that is because I believe it doesn't matter in this situation because, again, the attorney for Ms. Williams could not have filed anything once he was discharged. I do know that the time had not expired by the time he filed the motion to withdraw. And if there are no further questions, I will reserve the remainder of my time for rebuttal.
Thank you, counsel.
That's fine. I can see. It's not too far away. Good morning, Your Honors, and may it please the Court. I'm Diane DeWolf for the Appalachia Public Supermarkets. Your Honors, this case is not about due process, it's about due diligence. For more than 500 days, the parties here engaged in extensive discovery. Plaintiff gave her deposition, and plaintiff took multiple depositions of Publix associates during those 500 days. And after that time, Publix came to the conclusion that plaintiff could not prove constructive notice as a matter of law, so it moved for summary judgment. And the very next day, on October 28th, it noticed its hearing for summary judgment. And I don't have the exact case record for that, but I think Ms. Lawson conceded that that the summary judgment hearing was set. It was set for January 4th. That was more than 75 days, or about 70 days out from when the motion for summary judgment was filed.
Let me just ask you about that. So let's assume, it's not, I don't see it in the record, but let's assume that it was properly noticed on the 28th. In the record is a November order from the trial court that's a scheduling case management order, and it says what's going to be handled at the hearing, and it doesn't say that it's going to hear a summary judgment motion. It says that they're going to identify pending motions and set them for hearing at the case management hearing, and also to schedule a trial. Does it matter that the trial court issues this order after the notice?
I don't know that it does, Your Honor, and I know that I saw in the record that it was noticed on October 28th because I knew it was the very next day after the motion for summary judgment was filed. Now, the only motion pending at that time on November 4th would have been the summary judgment motion because the motion to withdraw hadn't been filed yet. That wasn't filed until November 4th, and those are the only two motions pending at the hearing. So we've set this hearing on a motion for summary judgment nearly 75 days out, and plaintiff doesn't file anything. She doesn't do it. What does she do? She fires her counsel 2 weeks later. She files her counsel. Now she says, I want to be represented by counsel. So why isn't she? Why didn't she substitute counsel? Why in those 75 days didn't she get new counsel? There's no prohibition against having multiple counsel, and there's no shortage of personal injury attorneys in Tallahassee that work on contingency fees, right? She doesn't file any of this deposition testimony that she's been taking for 500 days. She doesn't get new counsel. She doesn't file a response to the motion for summary judgment. She doesn't do anything. She doesn't do anything before the hearing. She shows up at the hearing for the motion for summary judgment, and the judge asked her, well, do you have any evidence? And all she says is, well, there's a video, and there was something on the floor, and I slipped in it. Shouldn't Publix be liable? No. Without something more, Publix should not be liable.
Well, when she's saying that, can we fairly conclude that she, with the way the transcript reads, that she understood that she was there to defend this against the summary judgment motion?
Your Honor, all I can say is this was noticed as a summary judgment motion. It was noticed way before. We also have, her deposition, which Publix filed, where she says the same thing. I didn't see it. I don't know what it was. I didn't look at the floor. I don't know where it came from. I don't know if any Publix employee knew it was on the floor. I don't know any of this, right? She doesn't move to continue the hearing. Nobody moves to continue the hearing. And it's also important, and I think you should look at this, is that the motion to withdraw does not ask for 30 days. The motion for withdrawal is just a motion to withdraw. It's the order that says, and you have 30 days to get counsel, right? That's the order that was later signed.
What is the point of that? What do you think the point of giving her 30 days to obtain new counsel is?
Well, I just heard the discussion before that he asked for 30 days. Now, probably the proposed order was sent at the same time as the motion for withdrawal. It was probably sent to the JA, whatever, but the motion itself doesn't actually specifically request that, and it was never requested. There was never a continuance requested. After the summary judgment hearing.
By saying you have 30 days to get counsel, doesn't that suggest that you have 30 days to get counsel or you're going to be representing yourself?
No, I don't think so. I think I have to agree with you. At first blush, you look at this order, it appears to be a little bit inconsistent with what happened, right? But is it error in the face of a complete lack of due diligence at any point by the plaintiff? You know, the court said, yeah, well, at this point, you know, you've had all this time. I have this evidence in front of me that clearly says they're entitled to summary judgment because you can't prove constructive notice as a matter of law. No jury would buy this. So right now, you know, this is what I have.
But, counsel, the motion to withdraw was filed prior to the time allowed for filing a response to the motion. And the trial court then gives the litigant, Williams, 30 days to get new counsel. Why shouldn't that 30 days apply to the time to file a response?
Your Honor, the motion didn't request 30 days. There was a.
But the trial court gave her 30 days.
Right. He did say that you can have 30 days, but at that point, what the judge had in front of him was no motion to continue. He had all of the summary judgment evidence in a case that had been pending for 588 days. He had nothing contrary.
Giving her 30 days to get new counsel be equivalent to continuing the case.
I have to agree with you, Your Honor, that the order appears to be inconsistent on its face. But is it error? I don't think so. Because of the reasons I've stated, because she had all of this time to do it. And after, does she move for rehearing, reconsideration? She had 27 days after January 4th to move for rehearing or reconsideration because the judge didn't enter the order for 10 days. So then she had another 15 days once the order was rendered, and that fell on a weekend, so she had a few more days. So it was 27 days. She still doesn't get counsel. She doesn't move for rehearing, and that's the difference between the Myers case and the Scheinheit case.
So you're saying it's not error, but let's talk a second about a similar question that I asked Appellant about the way we articulate the principle that we're addressing here. So when we talk about due process, generally we're talking about fair notice and a meaningful hearing, right? And so that's the core of our inquiry here, right? It's whether or not Ms. Williams had fair notice that this was going to happen and a reasonable opportunity to present her case and submit her objections and have a fair hearing, right? Tell me if I'm thinking about that right. Have I sort of cast the inquiry correctly?
I believe you have, and our position is that Ms. Williams had notice and a fair opportunity to be heard. She had every opportunity, she had every process available to her, but she chose not to take advantage of it.
How do we deal with the appellant's argument that once the motion to withdraw is filed, that is an implicit motion for continuance for everything substantive that the court needs to do? So it stops the clock on the summary judgment hearing. What argument do you have against that?
I don't think there's any case law to support that a motion to withdraw stops the clock on everything, Your Honor. She fired her counsel, so counsel moved to withdraw. She didn't want to proceed pro se, then she should have hired other counsel. She had every opportunity to do that, and she didn't do it, So that's my only answer. There is no rule of law that says a motion to withdraw stops the clock. I haven't seen any case that says that, and it does not. And I'd like to turn to counsel's second argument that I'm not sure she actually got to, but she said that public's motion for summary judgment and the attachments were insufficient to support summary judgment.
But before you dive into that, let me
Sure.
pull you back just a second. So,
Sure.
Tell me when you think that Ms. Williams actually began representing herself. When did she actually formally become a pro se plaintiff?
The very second she fired her counsel.
So what effect do you think the rule has that says the representation doesn't terminate until there's a written order by the trial court?
As I said before, Your Honor, there's no rule against having multiple counsel. She could have found new counsel, filed a motion to substitute counsel. She could have had a new counsel appear for her and moved to continue. She could have moved to continue on her own.
Sure, so she could have done those things, but she didn't, right?
She didn't do
So
those.
in this proceeding, at what point formally in the court proceeding is she no longer represented by counsel?
I believe she was no longer represented by counsel on November 10th when she fired her counsel.
Okay, thank you.
Now, Ms. Williams has argued that public's motion for summary judgment was insufficient, that it didn't provide all of these things that were needed to apparently disprove this case. And that sounds suspiciously like the old summary judgment standard. All Publix was required to do is point out that plaintiff lacks the evidence to prove her case, an essential element of her case. And Publix did just that. You can do that by attaching depositions, by attaching pleadings, by attaching interrogatories, by attaching all these things, and that's exactly what Publix did. After 500 days of discovery, Publix came in, moved for summary judgment, and it attached to its motion for summary judgment excerpts of Ms. Williams' deposition testimony, answers to interrogatories, and also depositions from the customer service manager of the store who was there. At that point, the burden shifted to plaintiff to prove that there were genuine issues of material fact that precluded summary judgment. She didn't do that. Again, she didn't file anything. She had all of these depositions. She took these depositions herself. She says, oh, there's a video. She didn't file the video. None of these things got filed. Now, remember, she still had, and I think this is the Guilhermes case. She could have, even after summary judgment was entered, she could have come back with all of those things. If there was something in there that would show a genuine issue of material fact, she had 27 days after January 4th to file it then, and she didn't do it. So, you know, that was her burden. It shifted to her, and that didn't happen.
I understand your position here, and it seems to me, had the trial court not granted Ms. Williams 30 days to find additional counsel, then we could have moved right into the summary judgment. You don't find the fact that the trial court, upon granting the motion to withdraw, then giving Ms. Williams 30 days to find new counsel, problematic in terms of the trial court moving right ahead into the summary judgment motion?
I don't find it problematic, Your Honor, because at that moment, the trial judge had everything in front of it needed to do to grant summary judgment and to decide the motion for summary judgment. And again, I'll agree with you. It does seem to be an inconsistent order, but no motion for continuance was ever made. No motion for rehearing was ever made. No evidence was ever presented. And plaintiff had every opportunity to get new counsel before that hearing. That hearing was properly noticed, and she had every opportunity to get counsel before then. She left herself as a pro se plaintiff on November 10th when she fired her counsel and she didn't get a new one. So no, at the very least, even if it is error, it's certainly not reversible error, it's harmless error. Because we have plaintiffs saying, I didn't see anything on the floor, I have no idea what I slipped in, I don't know how long it was there, I don't know where it came from, I don't know if any Publix associate knows it was there either. And the customer service manager says the same thing, and these are in the depositions that we filed.
So then the argument then is, even if it is a due process violation, that is, there's a failure to provide fair notice and a meaningful hearing, that it was harmless because from what we have, although we don't have a response or a meaningful response from appellant, that it looks like she would have lost anyways.
Well, Your Honor, first I have to disagree that it was a due process error. And I think
I'm just addressing your argument that even if it was error.
Even if it was error, it wasn't a due process error. It might have been, oh, shoot, I did this wrong, right? I shouldn't have written it that way. It wasn't a due process error. This case, again, this is about due diligence, not due process. And any error here, we believe is harmless. And if there are no further questions, we ask that this court affirm. Thank you.
Thank you, counsel.
Counsel says repeatedly that Ms. Williams had every opportunity to bring a new lawyer into the case. The fact is, her former lawyer asked for her to have 30 days, and she was denied that opportunity. Why she didn't bring a lawyer in before that as a substitution or bring a lawyer to the hearing is a question that the record does not answer. The reason the record does not answer that question is that no one asked. The trial court didn't ask because the trial court wasn't inclined apparently to find, and no one asked it to find, that Ms. Williams did not exercise due diligence in looking for a lawyer. As counsel pointed out, personal injury lawyers tend to work on contingent fees, so it's highly unlikely to expect another lawyer to come in while she still has a counsel of record. Also highly unlikely to think that she could get someone to come in once the trial court granted some public's motion for summary judgment. Certainly not on a contingency fee basis. Therefore, she had no one in the rehearing phase, and the record bears that out. And on the other issue, I just point you to, counsel argues that I'm arguing under the wrong standard. In fact, I'm arguing under the federal standard. The Clark case cited in the initial brief and the reply brief, but unacknowledged in the answer brief, bears my argument out. That case has been cited 7,400 times. It explains the current law. It explains that there's a lot of confusion about Celotex, and it shows that Publix's reliance on. I see my time has expired. May I finish my sentence?
You may.
It supports the argument that Publix did not point to anything in the record showing that Ms. Williams could not prove her case. And I would ask that this court reverse on that issue, and if not on that issue, then under Scheinheit on the first issue. Thank you.
Thank you, counsel. Thank you both. We will give you a moment and the counsel the next moment to approach the counsel table for the second case. Our second case today is Lee Madden and Tamara E. Madden versus Okaloosa County. Counsel, when you're ready, you may proceed.
May it please the court. My name is Joey Morris. I'm here today on behalf of the plaintiff/appellant, Mr. and Ms. Madden. We're here on appeal of an order granting summary judgment for Okaloosa County, thereby dismissing the Madden's suit against the county alleging damages caused by recurrent flooding on the Madden's property. The lower court's ruling is based upon a statute of limitations and laches argument, which was erroneous and should be reversed. From reading the defendant's brief, it appears that we all seem to agree on what the law is in this case, but it's just a matter of applying how you apply the facts to the law in this case. What this case boils down to is whether the damages incurred by Mr. Madden were permanent in nature or temporary. If temporary, then each occurrence of the flooding on his property gives rise to successive rights of action.
When did the flooding first occur on the Madden's property?
Flooding has been taking place on that property since he purchased it back in 2004. It's an ongoing, and in his deposition, he admits that the property probably floods 2 to 3 times a year when you get excessive rainfall.
And it was flooding before he purchased the property?
Yes, sir.
When he purchased the property, knew that this property flooded?
He knew, yes, sir. He knew, he did. In this case, the lawsuit that was dismissed was based upon occurrence that occurred on August 4th, 2017. A notice of claim was filed on January 8th, 2018, and the lawsuit in this matter was filed on May 28th, 2019. In this case, the damages that were occurred by Mr. Madden were of the type that were not permanent in nature. They were the type of damages that when the lake would overflow or flood, he would get debris into the lake and onto his property, and very few times it might come up to his porch, but then it would recede. There's no allegations and there's no damages claiming that this was permanent in nature, that it permanently damaged his property or his house.
Counsel, what record evidence is there that the asserted injury is abatable?
What evidence is it abatable?
Yes. What record evidence?
Well, there is a Okaloosa County Master Stormwater Plan from 2003 that's in the record. And in that, they specifically talk about Lake Haven, which is the pond or lake that's on the plaintiff's property. And in that, they make reference to a specific pipe that flows out to a certain street. This specific pipe is the pipe that takes water away from the lake. So you have pipes that bring water into it, and then you have a pipe that takes water out of it. And in that master plan, the recommendation is made to move from a 30-inch pipe to a 42-inch pipe to control the flooding. That was never done, but that was from 2003. So the type of damages he had were temporary. They were not permanent.
Does the determination on whether it's temporary or permanent turn on whether it's abatable?
No, I don't think it does. No, Your Honor. One of the things, there's a couple of different things, and I think from the town of Miami Springs case, or the Lawrence case, I believe it is, they said if the overflow is temporary, occasional, recurrent, causing no permanent injury to land, or if the situation involves other elements of uncertainty, such as the possibility of alteration or abatement of the causative conditions, or uncertainty in regard to the future use, or improving the land so as to prevent a reasonably accurate estimate of the future damages, then it is generally held that each repetition of the overflow gives rise to a new cause of action for which successive actions may be brought.
Can one assume that if it is temporary, that it is abatable?
Pardon me?
Can one assume that if the injury is temporary, that it is abatable?
I would say yes, Your Honor, because whatever makes up that drainage system, at some point it's enough to drain it out of there. So when it overflows, you have a heavy rain and it comes up, the pipes at some point do a job to get the water out of there. So, but it doesn't prevent the rise of the water like this pipe that was recommended be put in place to avoid the flooding. So there's obviously some issue after a substantial rain. What the court had in front of it when, again, this was a summary judgment, and we contend there were certainly genuine issues of material fact for the court to not rule the way they did, and some of the evidence they had in front of it was the testimony of Mr. Madden, who testified that back in the early 2000s when a certain, it's called Crosswinds Development, was built right across from his property. When that was put in, he testified that he noticed the drainage had increased into his pond. There is the deposition of Mark Siner. Mark Siner is an engineer of Choctaw Engineering. His deposition and his report are part of the record. And what is interesting on that is that when he was deposed, they asked him about did he see anything unusual, and he specifically chose a day when it was a heavy rain to go out there and inspect this property. He said, I found it unusual to see water flowing into the lake, and I'm just sort of summarizing it, but he said, I found it unusual to see water flowing into a lake on a pipe that is supposed to take water out of the lake. Again, just another piece of evidence there for the court to consider, the lower court. And then the court also had the master plan that I've referenced earlier in front of it to consider.
Did you raise the issue below of the increase in size of the pipe to the trial court? Was that argument made to the trial court?
That was submitted. I don't know if it was argued to the court.
Is it enough to just submit a master plan to the trial court and let them figure out if there's something in there that might work to preserve for appeal?
Sure. It was an exhibit. It was part of the evidence. The way the arguments went, and they were set aside, that the other side basically, and it just the way it worked, had most of the time in the argument before the court had to cut it short for another hearing or had to leave. So they had it as evidence in front of it. It was not specifically pointed out to the court during oral arguments that I can recall. So and I want to talk.
At any time did you argue about this increase in pipe made this injury abatable?
One more time, sorry, Your Honor.
And did you any time argue before the trial court that the increase in the pipe size, I guess from 30 inches to 40 inches, made this cause of action abatable?
That specific argument was not orally made to the court. No, Your Honor, it was not. I want to bring to the court's attention a case out of this district back from 1980, Department of Transportation versus Burnett. It's a very, very similar case to this, and in that case, the Department of Transportation did some work on some property, and part of it was putting in infrastructure. And it was a sloping piece of property, and they put in pipes, drainage pipes, things of that nature, and it was an ongoing project. And at one time, they went back and plugged one of the pipes, affecting the natural flow of the water such that it went in the reverse direction. After they did this, Mr. Burnett came to the property and bought property, 100 acres, and he bought it in two different increments. He bought one piece of the property in 72. He brought another piece of the property in 78. The infrastructure that affected this property was already done in 1968 or 69. When he bought the property, he did no formal inspection. He did not hire anybody to inspect the drainage, to inspect the topography or anything of that nature. When he decided that he wanted to develop the property and put villas and condominiums on it, and they started doing their due diligence, they found out that on a piece of the property, it's not going to be suitable for these villas because it will hold water at a heavy rainstorm. Part of this due to one of those pipes being reversed in the way the water flowed. In that case, the plaintiff alleged a permanent taking and asked for an injunction. The court there said, you don't get a permanent taking because the person who had that right was the one that owned the property at the time this development or this infrastructure was put in place. You came along afterward. But you do have a right to an injunction because this is a temporary issue. It's a recurrent problem. It's temporary. It's a continuous tort is what the court said. And they also said it's no defense that the drainage system was already in place. The defendant said, well, wait a minute. This system was already in place. He came here. He didn't do any due diligence. This was already here. The court said that is not a defense.
On the other hand, the appellees cite our opinion in Simon versus Deer Meadows Homeowners Association in support of their argument. Can you distinguish the Simon case?
Yes, Your Honor. Grab that. And I don't think I did, but I meant to ask for 3 minutes for rebuttal, and I apologize.
Okay, so noted.
In the Simon case, that's a 2019 case, this case is only about inverse condemnation in that case. There's no claim or mention of flooding or water damage in this case. This is only about getting the city, and that's all he wanted. If you read there's no complaint about, hey, this retention pond is flooding my property, it's causing damage. They only wanted the city to come in and pick up maintenance of that pond. The city had never maintained that. The prior landowners had maintained that. The current landowner had found that out, that, hey, it's the responsibility of the landowners to maintain this retention pond. And so that's the difference. To me, the cases really aren't similar at all, because it doesn't involve damage or flooding to the property. It merely involves getting I believe it may have been Tallahassee, I can't remember who it was.
Is the relief that you request in this case consistent with permanent damages?
The relief, if you read the complaint, we clearly set out this is temporary in nature, and the relief we're asking for is obviously the past, but also when you read it in under, I think it's count 2, probably the heading not as clear as it could be, because under count 2 we talk about the temporary damages that occur, the recurrence, but we also talk about how the county has used this without an easement, without paying for it, without doing anything to have a right to use it. So, within the damages, we do talk about the past damages, which you can which you can request for this type of case. But we do talk about continual damages, and in that sense, it's meant to. We don't want to waive any damages that we may be able to get because we have a right, or we can make the county pay for an easement or use of this retention pond, which they never have, even though they have always continued to put water into that property. And I'll reserve the rest of my time.
Before you sit down, counsel, one other question. Assuming for the sake of argument that we construe your cause of action as a suit for permanent damages, when did your cause of action accrue under that scenario?
If the court was to consider permanent damages, then I would, and there's been some talk about that in the briefs, I think you would have to look at either 2010, possibly, which is when the first notice was filed, notice of claim. It's possible the court could look back to 2002 or 3 when he came to the property, if you're going to consider this permanent.
Thank you.
Good morning, Your Honors. Carly Schrader from the law firm Neighbors, Giblin Nickerson, here on behalf of the appellee, Okaloosa County. In this case, the county submits the trial court properly entered summary judgment based on the undisputed material facts, and it was proper as a matter of law. The statute of limitations in this case, even giving every inference in favor of the property owner, ran at the very latest in 2010 when the Madden's attorney sent a letter to the county under a section 76828 recognizing the alleged injury and harm and asserting that the county was to blame for that alleged injury and harm. In that letter, and then the letter that Madden's attorney wrote, specifically stated that the county substantially deprived Madden's of the land's beneficial use and amounts to an unconstitutional taking of the property, and that with every rainstorm, there is stormwater runoff into Lake Haven from inflow pipes that are owned and maintained by the county. And probably the statute of limitations even ran much earlier than that, but giving every inference in favor of the property owner, it ran no later than that 2010 letter.
On the other hand, counsel, is the flooding of appellant's property abatable?
I'm sorry,
Is
Your
the
Honor.
flooding of appellant's property abatable?
Is it abatable?
Yes.
The county submits it is not abatable and that the undisputed facts show that. The stormwater system has been in place for the most part since the 60s and 70s. The area is built out. We submitted an affidavit from the county's professional engineer, who's the director of the Department of Public Works, that this would be even if you could do it under modding permitting standards, this would be in the millions of dollars. You would have to take other private property rights in order to reroute this stormwater system that's been in place. The case law that talks about things that can be abated does not contemplate the circumstances here. For instance, in the Carlton case, there's a talk about a crushed culvert. And that flooding was a result of that crushed culvert. And there was some evidence that that could be repaired and the flooding remedied. That is not the situation we're talking about here. The undisputed facts on summary judgment show that this is not something that the county could go out and alleviate.
What are the parameters, and how far do those arguments extend when it comes to whether a condition is abatable? How much money, impact on other property owners? What are the considerations that the trial court has to review before determining whether this is abatable or isn't abatable?
Well, where summary judgment has been successfully argued by other property owners, it's been in circumstances where they've had engineering testimony that said either it has already been abated by whatever actions has been taken, or that there is some remedy that would abate the issue. And here the evidence goes the other way. The county submitted evidence that you can't do this without completely rerouting streets by taking property, that this is not something that is appropriate for that abatement case law to apply for. It's more in the circumstance where you have that crushed culvert. It's something that can be remedied by the county to be able to alleviate those issues. Other cases where they have found abatement was appropriate was the conditions had already been abated, and they were able to show that to the
Counsel,
court.
for the appellants rely on the 4th District's opinion in Carlton versus Germany, Gross, in support of their argument. Can you distinguish the Carlton opinion?
Yes, and the Carlton opinion, I believe, is the one that pertains to the crushed culvert case. And in that case, the culvert was crushed in 1989. No suit was filed until 1998. And Carlton alleged the property had been continually flooded. And in that case, the court found that the defendant didn't meet the burden of proof, that there was no dispute of fact, that the flooding did not occur before the culvert was crushed, and that the culvert would abate the flooding. And so this is, if you look through the evidence that was submitted in this case, Mr. Seiner, who was the engineer on behalf of the Maddens, was deposed and his deposition transcript was submitted. And in that deposition, he was asked, is there some broken pipes that are in need of repair? Is there some engineering issues with the system? And he says, no, I don't see any broken pipes in need of repair. That was not something that was brought forward. So that's distinguishable from the Carlton case.
So it sounds like among the factors in determining whether something's abatable, a condition is abatable, is there a broken component in a functioning system, so a broken culvert, or something that is wrong? If the engineers say if like the culvert were operational, everything would work as designed. So that may be a feature, but it sounds like too that the impact on surrounding property owners and other land is an important consideration. So in a vacuum, yes, a condition could be abatable as to that parcel, but then it has collateral impacts on surrounding property. So how much weight does the trial court give that, and where do we get that from?
I think you do have to give that some weight. And if you look at the standard for injunctive relief, it's quite similar. You have to show that it's in line with the public interest. And here, the evidence supports that you cannot, there's nothing that you can do to alleviate the circumstances complained of without taking private property interest. This is a built-out area. This is area where subdivisions have existed around the property for decades at this point, including a development that was put in by the prior owner of this parcel, who directed the stormwater into this parcel. So that is another distinguishing feature of this case. You have private interests that developed reliant on this drainage pattern. So I think if you look at the case law on abatement, if you look at the case law on what you have to show for injunctive relief, that all of that is consistent here.
So with regard to, let me just kind of follow up on that abatement inquiry. So it seems like from a kind of pure standpoint that both of you agree that it is, it can literally be abated in that it can be rerouted, and it just may cost lots of money and affect other people. So is it that there's a kind of a reasonableness inquiry, like how much money and effort and people, the effect on other third parties that the court should be considering some reasonableness element for how much has to be done in order to abate it?
So, well, I think it's important here to highlight that the affidavit that was submitted by the county's engineer in this case says this is if it can even be done under modern permitting standards. So it's not even clear that you could even get a permit to do this work in this case. And even if you could, it's not practicable. And I think that is a inquiry that you have to make.
And why is it not practical?
It's not practicable because you would have to completely reroute these roads that have been in place since the 60s and 70s, private property interests, these subdivisions that have been platted. You're going to be stepping on the rights of those other private property owners who have relied on this drain that was put in by a prior owner of this exact property. So it makes this case quite different from the Burnett case. Also, the fact that there was a letter that was sent by the Madden's Council acknowledging all of these issues back to 2010. There is a line of cases that talks about that type of acknowledgement by a property owner that cause of action has accrued at that point. They have acknowledged the permanency of the damages at that point, that the county, they have alleged, is responsible for those. And under that line of cases, we have cited Suarez and Sanford and some of those, and a couple of other cases that are on that same line that says once you retract any permission to use that property, certainly it has accrued by that point. And there's not a series of continual tortious actions that the appellants can point to here. They're pointing to rain continually occurring in a stormwater system that was developed and put in place mostly in the 60s and 70s. And if you'll notice when appellants counsel discussed the disputed facts that they're asserting here, none of those actions are things that have occurred within the statute of limitations timeframe. He's talking about the development of a condominium that's south of the property. That was developed in 2001.
Counsel, regarding the county's laches argument, is the county relying solely on the equitable defense of laches or also on the statutory laches set forth in section 95.116? 0.11.6.
Yes. Yes, and so the county's also asserted, and the trial court entered its summary judgment on the defense of latches, and that goes to the injunctive relief component here,
Can you explain the difference
equitable
between
relief.
the two different latches, by the way, before you get into the argument part? Can you explain the difference between the two types of latches?
The difference
equitable
between,
versus-
so the statutory latches relates to if there is a cause of action that's recognized, that there's a recognized statute of limitations on, that latches doesn't extend any further than that statute of limitations time frame. And then the latches in the case law similarly It's a sitting on rights where there is prejudice to the other party. And so it bars an action unless it's commenced within the time frame provided for legal actions concerning the same subject matter under the one standard. Under the other standard, it's whether there's an omission to assert a right and the delay is unreasonable, and that's prejudicial to the defendant or third parties, which I think is certainly the case here for the reasons we've talked about. It's prejudicial to the county because the county has spent money in maintaining the system over the years, and in reliance on that and taken actions in reliance on that system, it's prejudicial to the rights of third parties also. So we would submit that laches also applies in this case and that the trial court properly entered summary judgment on that basis as well.
To take you back to the temporary and permanent inquiry, I'll ask you the same question. Do you view the determination of whether it's abatable as dispositive for that determination?
I think it's certainly a factor, and it's based on some of the case law that we've cited in the briefing. I think certainly it's also appropriate to consider the line of cases which have recognized that where a appellant has recognized the permanency of the condition, has put the other, has asserted that they are aware of the permanency of those conditions, that the statute of limitations certainly begins to run by that point. They're retracting permission to use the property for any of those purposes. They're recognizing the permanency of the conditions, and the case law supports that the cause of action should accrue, giving every inference in favor of the appellants by at least that point in time. We think the county believes it ran much earlier. None of the basis in the complaint go past 2001. The system's been in place since then. Even the development across the street was put in no later than 2001. But given every inference in favor of the appellants in this case, it ran by no later than 2010.
The trial court found that the appellants failed to comply with the section 768.286 notice requirements, also as a basis for granting the county's motion. Assume for the sake of argument that we construe appellant's action as a suit for temporary injury. Would you agree that the 2018 and 2019 claim notices would be timely under section 768.286?
If you were saying we have to assume that it's temporary and the statute of limitations starts over with every rain event, then that would only go back to the statute of limitations time frame. So things like this case was filed in 2019. So anything that goes back prior to 4 years, which some of the flooding events certainly did, that would be certainly outside that time frame. And so the issue under 768.28, certainly the 2010 letter doesn't meet the standard here for this lawsuit. As to the 2018 and 2019 letter, the 2019 letter was the only one that was actually attached to the complaint. The 2018 letter was submitted, I think, 2 days before summary judgment. But in any event, you would only go back the statute of limitations time frame. So it would only be events within that time frame that would apply.
Within the 3-year time frame? Within
the 4-year statute of limitations time frame, and then 3 years from the letter.
Notice.
Yes. The county submits that the Burnett case is distinguishable, that none of the material disputes of fact that the appellants have tried to identify are within the statute of limitations time frame, and would ask, in terms of, just real quick, to address the issue of the pipe, there was no engineering testimony that would alleviate or abate any of the issues here. There was some speculation, some lay deposition testimony to that point, but no engineering testimony that would support that point. We believe that summary judgment was appropriately entered in this case and would ask the court to affirm on all bases.
Did the appellants offer any evidence in support of abatement in the proceedings below?
I'm sorry, I didn't hear the
Did
question.
the appellants offer any evidence in support of abatement in the proceedings below?
Did they support any evidence of abatement? I would say no.
Specifically in support of abatement in the proceedings below?
I would say no.
Thank you, counsel.
Thank you.
I'll I'll ask the clerk to add 30 seconds for the appellant. We'll give her a moment to do that.
Just a couple of things to follow up on. I disagree with, on the Okaloosa Stormwater Drainage Plan. It clearly said in the report that I talked about earlier regarding the pipe that would take water away, that it would help with flooding problems. It was very clear in that document. Also, the question was raised about, they talked about the expense of having to do, that this may affect other homeowners, may affect other land. And I keep going back to the Burnett case because it's really on point. And at the very end of that opinion, the court said, quite possibly the department is unable to restore the old northward drainage pattern without causing unmanageable water on North Florida Junior College. Condemnation of some land or easements may be appropriate to manage this drainage in compliance with the injunction, but the manner and method of so relieving Burnett's land are for the department to determine in the exercise of its lawful powers. And so what it was saying is, look, yes, these things may get affected. You may affect other lands. You may affect other properties. But if it fixes the problem, it has to be looked into and investigated. What we have and what she's talking about, that where she said it was testified that this would cost millions of dollars, that was just an estimate. I mean, if you think about it, all these pipes, these drainage pipes, the county has right-of-way on it. It's there. These pipes run on right-of-way property. They go, and it happens all the time. When you upgrade pipes, they dig up on their right-of-way property, they put in new pipes. They dig up on the side of the highway. They put in on right-of-way property, they put in new pipes. So this is what we believe in the stormwater report, where it says go from 30-inch to 42-inch, never done, never investigated, might relieve this flooding problem. And so I would ask the court that we have put forth more than enough evidence, I feel like, for the lower court. We had enough evidence that we should have been able to go forward without being dismissed on summary judgment. Maybe it gets on down the road and we lose, but it was not the proper time for us to go out on summary judgment at that point, especially with the evidence that was put in front of the court. So I'd ask this court to reverse the summary judgment so that we can continue toward a resolution of this case.
Thank
Thank
you,
you.
counsel. Thank you both. All counsel are invited to join us for coffee. This court will stand for recess.
All rise.
Back to my office.
All rise.
Please be seated. Our last case on the docket today is Devil's Garden Investment LLC, Devil's Garden Aquaculture versus South Florida Water Management District. Counsel, if you're ready, you may proceed.
I'm ready, Your Honor. Thank you. Good morning. May it please the Court, I'm Ken Ortel here on behalf of the appellant Devil's Garden Aquaculture. This is an appeal from a final order by an administrative law judge regarding a rule challenge petition I filed on behalf of the client. As a little preface to this, we applied for a variance from certain rule requirements of the district. And the rule states that a landowner who owns property in the C-139 basin described in the EFA. Now, I want to just mention the EFA is the Everglades Forever Act, statute passed by the legislature, and it has permitting requirements in it for people who discharge into the basin. And the whole purpose of the act is to try to protect the Everglades. So my client, who has property in the C-139 district basin, filed this request for a variance. The rule of the Water Management District requires that a property owner who seeks a variance must submit evidence that its discharge doesn't use works of the district. In plain language, it means you're not using the basin to clarify or assist the water quality that you're discharging. That's sort of background to this case. So what my client did was hire a hydrologist to prepare a report and submit the request for the variance, which Mr. Whalen did. And what he said was, I've examined the property, and I can tell it doesn't discharge. You don't have a discharge on this property. There's no pumps. There's no discharge structures. All the water is contained on site. The district denied the request for variance. I filed a petition for an administrative hearing regarding that denial, and eventually it became clear, and this is the subject of this appeal, that the district required, and it's stated in several documents, that my client engage a professional engineer to submit a report that the property did not discharge during a 100-year, 3-day storm event. In plain language, it means my client had to hire an engineer to demonstrate that the property wouldn't discharge any water in a century. The rule says you have to show that your discharge isn't going to use the works of the district. Well, we said we don't have a discharge. So the objective of this appeal is to challenge the administrative law judge's decision that the requirement to obtain an engineering report showing you didn't discharge water in a century is an invalid rule because it creates a requirement. It's not adopted pursuant to rulemaking. That is an obligation in Chapter 120, the Administrative Procedure Act, and it modifies the existing rule. All the rule we applied under says we have to submit evidence that our discharge, which we don't have, doesn't use works of the district, period. That's what it says. In our negotiations with the district and in their answers to interrogatories, they made it clear that this is an additional requirement to that rule, that we had to submit an engineering study that shows no discharge in 100 years.
So the premise of your rule challenge is that the 100-year storm requirement is not reasonably calculated within the language of the rule.
No, it's not adopted as a rule, and therefore it's automatically invalid. If it meets the definition of a rule, and it isn't adopted in the Florida Administrative Code pursuant to rulemaking, it is de facto invalid. And that's the problem.
Let me rephrase my question. If use of the district's works would reasonably encompass discharge in a 100-year storm, would it still require rule promulgation?
Anytime I hope I'm answering your question. Anytime an agency adds a new criteria and a new requirement to a member of the public, affected, regulated member of the public, they have to adopt it as a rule, if it meets the definition of a rule. And I think that's the central point of this case. Does the district's ad hoc new requirement that Devil's Garden engage an engineer to satisfy the rule waiver, is that a new criteria that meets the definition of a rule? And definitely it is.
All right.
It creates.
So let me say the same thing, but in a slightly different way. A hurricane comes along. It's a 100-year storm, and the property does, as a result of this storm, discharge into the works of the district.
Let's assume that. Yeah.
Yes.
Right.
Because of this storm. Your position presumes that that would not be use of the works of the district.
No. I don't know whether it would or wouldn't be. In a 100-year storm, the whole area might be flooded, and nobody could perhaps tell whether any nutrients were improperly discharged. The problem is the requirement itself of a engineering study, which the district emphatically stated it demanded that we submit one in order to be eligible for the variance. That is a requirement that isn't in a statute or a rule, and it was invented by the district in this case. And what is most troubling about the administrative law judge's ruling was that he said this only applies to one property owner, and therefore it's not generally applicable. That's an extremely dangerous precedent because almost all agency regulatory actions involve individuals, property owners, licensed people Florida has over 300 occupational licenses the state issues to all kinds of activities and professions.
So what is the right way then what's the right way to determine if it's generally applicable?
To determine if it's a rule?
No, if you're saying he couldn't determine that it was generally applicable or not based on this fact pattern, what is the proper way for us to determine that?
Well, the proper way for the district would be to adopt this as a rule.
What's the proper way for us to determine if what they're doing is generally applicable?
Oh, if it is a rule? Or what I was saying was the danger about this decision is it would give an agency a green light every time it's dealing with an individual to invent a new criteria.
Well, let's talk a little bit about the context in which this 100-year proposal arose. It's my understanding of the record that the application for variance was denied before there was any discussion of this.
Right.
Okay. And what was the basis of the denial at that point?
They based it on the other rule criteria that a hardship wasn't demonstrated and that there would be some unfairness in the way the denial was done.
So the agency had an independent basis for denying the variance.
That's what they said, yes. And that's when I filed my challenge to that decision. When it became apparent that the district was imposing this requirement for a study of a 100-year engineering study, that's when I filed the rule challenge, because then it became an insurmountable hurdle to get a variance on a criteria they invented for the purpose of this case.
And counsel, I just want to make sure I really understand the context well, though. Again, so there was a denial. You filed a petition for an administrative hearing, and at that point, the agency offered this way to cure their concerns with the permit. Is that, or to say it more plainly, they were negotiating?
Well, they said, you're going to have to do this. We're not going to give you your waiver unless you do this study, period. And that meets the definition of rule. The administrative law judge, in his final order, he stated that, I'll read part of the final conclusion. He stated that the statement requiring the study was specific to petitioner's property, not generally applicable, and didn't have the effect of law. Well, any requirement that an agency imposes can be a rule. And the ALJ cites the environmental trust case. That case didn't say what the ALJ said it said. That case said if an agency statement merely repeats what's obvious, it's not a rule. But it said if it merely clarifies another existing rule, it's not a rule. But if it does establish new requirements, it is a rule. And that's exactly what this requirement of the agency upon Devil's Garden, you must hire an engineer and do a study of a 100-year storm. That requirement.
This requirement or statement from the agency was made as a part of the settlement discussions?
We can say that it was, but it still was a requirement they invented and imposed upon my client and gave him no alternative. That's a rule. That's what all the cases this
Is there any
court
evidence
has.
in the record that this statement is generally applied, that it is imposed on other applicants other than Devil's Garden?
We may be the first person that ever applied for a variance under that rule. As far as I know, we probably were. But an agency must follow its own precedent. So if another person, a property owner, comes along asking for a variance, the district is going to have to impose this on that person too. Otherwise, they're acting in a manner that this court has said is a violation of equal protection. So this is a very important issue. An agency can't, in dealing with the members of the public, invent requirements and criteria that aren't in their existing rules or the statute. And that's what they did in this case. I'd like to save the rest of my time for rebuttal if there are no questions at this time. Is that all right?
Thank you,
Thank you
counsel.
very much.
Good morning. May it please the court. My name is Robert Glass on behalf of the South Florida Water Management District, and with me is Attorney Savannah Middlebush, also with the South Florida Water Management District. And I'm going to start off by talking about environmental trust, because that is a case that appellant brought up. And in that case, this court made two important points that are salient for this case. First, rulemaking is not required for every possible variation on a theme. And two, rulemaking doesn't apply to every kind of statement an agency may make. The upshot in that case was the agency is allowed to take information it's given and apply it to existing law and existing rule. In that case, like the word integral, this court held that rulemaking was not required for every possible interpretation of the word integral based on the specific facts presented. So fast forward to 2021, the district denied appellant's request for a waiver of the C-139 basin requirements, and an administrative challenge was brought. As part of the discussions that then ensued after litigation was commenced, appellant asked what it could do to satisfy the district and get this waiver. So the district did exactly what Environmental Trust said it could do. It reviewed what had been submitted. It conducted a site visit. It considered the existing environmental resource permit that actually allowed appellant to discharge water from its property and said, under these circumstances, to make sure that the purposes of the Everglades Forever Act are being met, we're going to require this engineering report showing how water is going to flow in a 3-day, 100-year storm event. And I think it bears emphasis, as this court has already picked up on, these were letters that were exchanged in a negotiation to resolve this amicably. Attorney Lamonaco's letter, page 56 and 57 of the record, is very clear that this was a site-specific concern based on the property boundaries on the northern and western sides. This wasn't a demand letter. This wasn't an agency final order. The district took no formal action on the basis of this request. And in fact, it was a negotiation. Appellant could have made a counterproposal, but didn't. So based on these facts, the ALJ found there's no rule here. And for the same reason, the district is asked this court to affirm, one, because the alleged rule doesn't have the force and effect of law, and two, there's no evidence in this record that it's been generally applied. So turning first to the force and effect of law, I mean, this court has said that a rule must create rights or adversely affect other rights. You need to look at the effect of the statement on the party. Well, the prohibition in the APA on relying on unadopted rules is specifically focused on agency action. If you look at section 120.564E, in the event this court finds there is an unadopted rule, the relief is the agency can no longer use it, rely on that statement for agency action. In this instance, there was simply no agency action taken based on this request from the district for this engineering report. I'd liken it a little bit to the Capital Collateral Regional Council case where DFS prepared a report, but then DFS never took any action on that report as to whether the regional counsel's office was an executive branch agency or a legislative branch agency. So this court held you couldn't preemptively attack a statement as an unadopted rule until the agency tries to take some action.
So in this case, I mean, it's pretty unequivocal. The agency says to secure the waiver, you have to have this 100-year engineering report. So what you're saying is that the agency would have to we have to wait until the agency actually uses that and denies it on that basis before we could consider it a rule.
Correct, yes. There has to be some formal agency action taken that affects substantive rights. And, agency action has a specific definition. It requires that the order be indexed, that it be filed in the Florida Administrative Register. And here, again, we have exchanges of letters between counsel. So it doesn't rise to the level of agency action.
Can you address the general applicability issue and talk to us a little bit about how we should be thinking about that in the context of the facts of this case?
Certainly. One of the elements that makes a rule is that it has to be generally applicable, either to to all applicants or a certain subset of applicants. It has to be a categoric application. And instances where you have discretionary standards or circumstantial, the principles only apply under the circumstances. Those cases, this court has found that they're not rules. Like, for instance, in Schluter, the Department of Highway Safety and Motor Vehicles statements, 3 of them were not rules because they were applied depending upon the circumstances, or they were applied at the discretion of the supervisor. It was the same in the Chief Judge's opinion in Coventry First, where OIR had the power to order and require compliance with insurance companies to submit records and of out-of-state insurance policies as part of an audit. But again, that was applied at the discretion of the examiner. It was not a categorical rule that all insurance companies had to submit this evidence. In this instance,
what if the district is just being arbitrary and sometimes they require this and sometimes they don't? Does that what's the proper remedy for appellant under those circumstances?
Well, I think in this instance you have to look at the rule requires an applicant to submit evidence that demonstrates that they're not using the works of the district, and Section 120.542 requires the district to base any decision on a waiver on competent substantial evidence. So when somebody applies, the district has to have some discretion there to determine whether the evidence meets the standard of, does it show that they're not using the works of the district, and 2, is it competent substantial to support their request? In that instance, if an applicant is dissatisfied, they have their remedies under Section 120.57. They can challenge that finding that it was insufficient, and that's their remedy.
If they are discharging into the works of the district in a 100-year storm, are they using the works of the district?
That is sort of an open question, Your Honor. I think it's something that appellant could have raised in front of the ALJ as to the meaning, the term use and how far use stretches. I know it was raised in the appellant's brief. I think in this instance, there were concerns regarding the property itself, and that's why we asked for that level of that type of study. But I can't say as a matter of law that a 100-year storm event would be using the works of the district. In terms of general applicability, I'll just step back to that for a second. Some of the cases that appellant cites, like Balsam, in that case, there was that, even though it was only a finite period of time, there was a general moratorium on the issuance of certificates of need. So any applicant who applied during that period would have their application rejected. So that kind of categoric application is what you need to establish general applicability. In this case, there's no evidence of that. There's very little evidence of whether this has been applied before, whether it will be applied in the future. Appellant could have sought to take discovery to see if there were any district records or depose district employees to see how they would resolve this type of question in the future, and that was never done. And then, this was appellant's burden to establish that there was an unadopted rule being applied in this instance. And the district's position is they didn't meet that burden.
Okay, I'd like to go back to the posture that this case was in. So the district had already denied the request for a waiver, and you're in negotiations of some sort. What are the limits on what the district can require or ask of an applicant before it will then grant a waiver? What are the boundaries on that?
Well, there are remedies under Chapter 120 if a party feels like the district is stretching it too far. For instance, in Section 120.542, an applicant is allowed to say, you're asking for too much, this isn't authorized, this isn't salient, and ask the district to process the waiver as is. Again, you would also have a remedy under Section 120.57 that my substantial rights have been affected by this onerous requirement that is being placed on me that is not rationally related to the rule itself.
Correct. So essentially, the applicant could say, the statute says that the waiver shall be granted if A, B, and C are present, and the district is trying to add D, right?
Correct.
So you proceed under one of the other administrative rules to challenge that action.
Correct. There may be a remedy there, but on this record, it's not an unadopted rule. Is the district's position here. And I just did want to touch briefly on one other point that appellant made in their reply brief, that this is an amendment to a rule. And just first, in the Matthews case, this court talked about how a statement that deviates from an existing rule, if made once, is not an amendment. It would have to be repeated to show that general applicability and that categoric type of application before one errant statement would be seen as an amendment. And two, again, just bringing it back to a point I made a few minutes ago, is the district has to support any decision on a waiver with competent substantial evidence. So obviously it has to have some, however limited, discretion to determine what would be competent and substantial under the circumstances. Otherwise, the legislature wouldn't have granted, if the legislature intended that any evidentiary submission would be sufficient, the statute would say that. And here it said, no, it has to be competent substantial, so the district has to be able to determine that it's relevant and will support the proposition for which it's being used. And if there are no further questions from the panel, the district would respectfully ask the court to affirm the order of the ALJ, and I will yield the remainder of my time.
Thank you, counsel.
With regard to the answer to one of your questions, Mr. Glass gave, that there has to be agency action based upon an unadopted rule in order for it to be determined to be invalid. That's not correct. A rule is defined as an agency statement. And in my brief, I've cited to the Wingfield development case, which also cites to the Balsam decision, both of this court. In Wingfield, the DNR, Department of Natural Resources, wrote a letter to a project saying, you're no longer qualified for your exemption from the coastal construction control line because you haven't been under continuous construction. That was a letter written to one property owner. And this court said that letter made up criteria not in the statute or in an existing rule, and it is therefore invalid. That's exactly what happened in this case. I got a letter from the district's lawyer saying, we will require you to do this study of the 100-year storm. And the Balsam case, which is cited in Wingfield, stated that a rule is an agency statement, and if it requires additional information not specifically required by a statute or an existing rule, it's invalid. Now, that is, again, exactly what happened in this case. Their rule only says submit information or evidence, which we did. Now, they might not have liked the evidence, and they could have said that, but what they did in the end was to say, this is the only way you can get this variance, and it is by commissioning this study from an engineer, which is not contained in the rule. And definition of a rule also includes the amendment of a rule. They, through an ad hoc basis, amended their own rule by adding a criteria for Devil's Garden to be eligible to get the variance. There's no guarantee if we hired an engineer we would have gotten it anyway. They might not have liked his work. That would be to be determined later. But what they did was to add a criteria to a rule. The administrative law judge said, since it only applies to one entity, it's not a rule. That's just wrong. That's contrary to many decisions of this court. The only question is, was it an agency statement? Yes. Did it solicit new information, not in a statute or a rule requirement? Yes, it did. It's a rule, and it's an invalid rule because it's not adopted in the administrative code. Thank you for your attention.
Thank you, counsel. Thank you all. This court will adjourn for the day.
All rise.